Good afternoon, everyone. Welcome to this afternoon's Know Your Rights webinar on unemployment compensation and workers' rights. We have with us today attorney Marissa Delgado from the Southeast Louisiana Legal Services. Please help me in welcoming Ms. Delgado.
Hey everybody, I'm going to start to share my screen. I have a presentation, PowerPoint. I'm just going to share it right now and we'll get started. I'm going to let you know a little bit about who I am and a little bit about Southeast Louisiana, and then we'll get started with talking about unemployment. So let me share my screen right now. Okay, so I'm going to share the PowerPoint. So again, this is the Law and Library by SLLS, and this is the Know Your Rights series. So a little bit about SLLS. We provide free legal aid for low income and vulnerable people. We specialize in civil legal aid. Our mission is to seek justice for low income people in Louisiana by enforcing and defending their legal rights through civil legal aid, advocacy, and community education. We cover 22 parishes across Southeast Louisiana. We have offices in Baton Rouge, Covington, Hammond, Harvey, Houma, and New Orleans. I personally work in the Baton Rouge office, and for Ascension Parish is covered by the Baton Rouge office as well. And in order to qualify for legal services, you must qualify by aid, and this is based on income and the type of legal work that is involved. So the best way to contact us, you can apply online at www.slls.org, or you can call our COVID-19 legal hotline at 1-877-244-7871. The other thing too is if you're located in Ascension Parish or East Baton Rouge Parish or surrounding locations, you can contact our Baton Rouge office. That number is 225-448-0080. Again, that number is 225-448-0080. And I provided that number at the very end of our presentation as well. So what issues are typically covered by our COVID hotline? We are covering evictions and landlord-tenant issues, foreclosures, employment law disputes, unemployment compensation denials, which is what I'll go into a little bit more, public benefit denials, child care support decreases, and custody violation and visitation issues related to COVID-19. And there's so much more that we cover. We also have a Facebook group, and we have presented Facebook Live presentations that cover these topics as well. So if you have multiple issues going on, definitely take a look at our Facebook group and look at our Facebook Live videos, and you can see different presentations and that get into those issues in a lot of depth. So, there's other topics we cover. We cover domestic violence and other family law issues. We cover landlord-tenant issues, home loan issues, modification and foreclosure. We cover disaster law, including any issues with FEMA. We cover government benefits, wills and succession, low-income taxpayer bankruptcy, consumer law, employment law, full access, child and care in need of care, and other kinds of special projects. Again, here's a list of the different issues that we cover. For public benefits and employment, we do handle unemployment benefits, we handle wage demands, and we handle wrongful terminations. We can give a little advice on those issues. And I'll get into more detail in a minute. And then this slide covers the income levels. It's important to remember that even if you don't match an income level, we do work with special grants that give us a little bit of room to cover more people based off of their income. So, always give us a call and we'll see if you qualify for a special grant as well. And this program is brought to you by your public library in partnership with Southeast Louisiana Legal Services. And we have generous support from the Legal Service Corporation, United Way, the Louisiana Bar Foundation, and other great organizations. So again, today's topic is employment law. So these are the three main issues that we see in our office. We see a lot of issues with unemployment compensation, unpaid wage claims, and wrongful termination. So this is what I'm going to cover today. The first issue is state unemployment. So with state unemployment, there are several qualifications you need to meet in order to qualify for unemployment compensation. So the first thing is, you must be available to work. And what that means, according to the Louisiana Civil Code, is that you must be physically available and able to work. So what we see a lot of the times is if somebody is sick, if they're out for a week because their doctors say, hey, you have a sinus infection, you need a rest, they don't qualify for unemployment for that week because you must be physically able to work. But there's ways to get around this issue that I'll go into a little bit later. The second thing is that you had to not have a disqualifying misconduct as a reason why your job ended. Misconduct that is disqualifying is anything that's connected to your employment. And what that means by disqualifying, and this is from the Civil Code as well, as that the mismanagement of a position of employment by action or inaction, neglect that places in jeopardy the lives or properties of others, any type of dishonesty with your job, other wrongful doing, violations of the law, or violation of policy or rule adapted to ensure orderly work or the safety of others. A big thing to point, though, with disqualifying misconduct is that you need to have the wrongful intent to commit this conduct. So what that means is that your employer needs to show that it was your intent to commit the act that is misqualified or disqualifying. And I'll get into that a little bit later. The other issues that we see with state unemployment is a voluntary quit. And this means that in order to quit your position and still receive unemployment compensation, there needs to be a good cause attributable to a substantial change made in the employment by the employer. What this means is that something must have happened that changes your job, and it wasn't on you, but your employer that made that change, that changes your, a variety of things that ultimately is substantial in nature. So it can't be just a little thing like, oh, they moved me from working the back of the house to the front of the house. It has to be something big. And then the last thing we see is issues with reporting duties. So part of receiving unemployment compensation is making weekly certifications that you are, one, available to work, and two, that you have been doing your job search. So you must provide truthful answers, and every week when it's your day assigned, you report to the Louisiana Workforce Commission that you're still available to work for that week and that you are doing the job search that is required, that you're trying to go on interviews, and that you're still looking for a position. So to get into a little bit more about these issues that we see with unemployment compensation, there's different ways to get around these issues. So let's say something pops up, you apply for unemployment, and the first thing they tell you is that you were not available to work, therefore you do not qualify for unemployment compensation. One way to get around this is to provide a doctor's note saying that you are able to work. So going back to my previous example, let's say you have a sinus infection, you're out Friday and Saturday, and Sunday, but on Monday you can get back to work, and the unemployment agency says, no, that whole week you were not available to work. What you can do is provide a doctor's note with the days that you were unable to work to the LWC, so that way they can see that you were available to work the other days as well. The other issues that we see with availability to work is that sometimes we have people who, for whatever reason, they're not able to go to work because they don't have a car, or that there's no way for them to physically get to work. Something that you can do, like if that's, an issue is traveling to work, you can show a mechanic bill showing that, your car is able to run again, so therefore you're able to go back to work, or you can show your bus pass showing that you do have transportation to get to the job site. So those are some ways to get around the availability to work. For disqualifying misconduct, let's say you apply for unemployment and you meet all the financial standards, and then come back and say, look, your old employer said you were fired because of X, Y, or Z. What you can do is you can actually fight that disqualifying misconduct by a variety of ways. So a lot of these ways that you can fight misconduct all hinge on the intent. So you must show that you did not have the intent to commit the misconduct. And there's a couple of ways. One way is to show that this was a single isolated incident. Let's just say that for whatever reason something happened and you reacted to a situation. If you are able to show that you have a good job record, that this was a reaction, you just didn't have time to think, this is just a jerk of the knee kind of thing, you can show that this is a single isolated incident and that you lack the intent to commit that misconduct. The other ways to show that lack of intent is to show, when it comes to poor work performance or the inability to perform job duties, you can show you weren't trying to commit a misconduct. Instead, you were trying to do your job. You just were not qualified to do that job. You can still get unemployment, even if you were unqualified to complete the job up to the employer standards. The other way is to show, it was another employee's fault. You were not the one to commit the misconduct, or you lacked the intent to commit the misconduct. A great way to do this is to say, my manager told me to do this job, and that it was the manager who actually had the intent to complete the misconduct, not me. I was following the rules. That's a great way to show that you lack the intent to commit the misconduct. And then the final way that you can fight disqualifying misconduct is to show that there was a reasonable basis for committing the disobedience. For example, if you were serving the employer's interests. One way you can do this is, let's say you're at a checkout line and you see that there's a long line of people, and your job is to sweep the floors. If you go open up, a register, and you're qualified to open up a register to help with the line, you can show that you're serving the employer's interests and that you should have not been disqualified for misconduct. And then the other issue, again, was a voluntary quit. So some ways to fight this voluntary quit is to show that there was a change in your schedule. For example, if you're going from day shift to night shift, and you were only hired to work day shift, and you no longer are able to work because you've got switched over to night shift, so you had to quit that position, that should be a substantial change in the workplace. The other thing is, if there is a change in your pay, that is still considered a substantial change in your workplace. Let's say your employer just stops paying you, that also is a substantial change in the workplace. And some of the issues that I've seen also are people that have gone from full-time to part-time, or from part-time to full-time. Again, that would be considered a substantial change in the workplace based off of the employer. So what do you do now that you've been disqualified and you believe you can fight the disqualification? You should appeal, and you should appeal right away as soon as you receive the disqualification. If you look at the appeals notices, you are only given 15 days to appeal, and if you do miss that 15-day appeal deadline, you lose your right to appeal, and it stands on record that disqualification still is in place. So, the best thing to do is, as soon as you receive the letter, you should appeal, and there's several different ways you can do that. You can file your unemployment claim appeal by letter. You can go online through the Louisiana Workforce Commission under your Hire account. If you go through your Hire account, you should be able to look at your claim summary and your unemployment appeals. And if you look under the unemployment appeal section, there is a form that you complete that completes the appeal for you, and it's electronically submitted. The other way you can do that is you can mail the appeal section of the disqualifying letter that you receive. So when you get disqualified, you normally receive a package of papers that includes the disqualifying letter and then an appeal form. So what you want to do is you want to fill out the appeal form and make sure to sign the signature page of the appeal form, or the LWC will consider the appeal will not consider the appeal unless it's formally signed by you. You can mail that appeal form to the Louisiana Workforce Commission Appeals Unit. And as you can see here, here's the PO Box 94094, Baton Rouge, Louisiana 70804 9094. It is important to note that if you do appeal by mail, you must have the letter postmarked no more than 15 days after the date of the determination of disqualification. If you file the appeal by mail, enclose a complete copy of the determination with your letter of appeal, and you must also sign the letter to file the appeal. So if you do mail the appeal form, just make sure to get it in the mail before that 15-day deadline, or else they'll consider the appeal untimely. And most of the time, unless you have good cause as to why you did not appeal on time, they'll consider the appeal complete. Okay, and just to go, now that you've appealed the notice, the next step in appealing a disqualification is to have a hearing with an administrative law judge. An administrative law judge is somebody who works for the Louisiana Workforce Commission that determines the facts of the case to see if there was a determining misconduct, if you were available to work, or if there was a substantial change in the workplace. So what the ALJ does is, most of the time, these hearings are through a telephone. So the ALJ will call you up. You will talk to the ALJ to kind of discuss your termination. Normally, the employer will also have the chance to discuss the termination. The ALJ will ask you questions. And if your employer is on the phone, you can ask questions about your termination to the employer as well. And then the ALJ will ask questions to the employer too. So it's kind of like a little hearing that happens. They're normally about 30 minutes long. It's really informal, like the rules of evidence that you normally see in a courtroom don't really apply in these kinds of situations. And with this kind of situation, it's best just to answer everything that the judge has. What I like to do is I like to think of all the questions that the ALJ may ask during the hearing ahead of time and try to come up with a reasonable answer and have that prepared, so that way when the judge asks you the question, you can give them an answer that completely tells your side of the story. So it's always best to think ahead of time and to try to think of a good answer to certain questions and really show those, helpful hints that I gave. Like for example, let's say, you had a hothead incident. You can tell the judge, look, this is what happened to me. X, Y, and Z happened to me, and I didn't have a time to think when I said that certain comment or when I made that certain action. It was just a gut reaction. It wasn't my intent. And that is kind of along the lines of things that you can tell the ALJ to help you in these kinds of situations. Now, let's say the ALJ listens to the story, he listens to the employer, and the ALJ determines that you did commit the disqualifying conduct. So what happens is, that's not the end of it. You can always appeal to the Board of Review. And what the Board of Review does is they look at your hearing and they look at everything that was put on record with the ALJ. They also will examine any kind of evidence that you submitted to the LWC, and then they'll also examine your appeal letter. And what they'll do is they'll take a look at everything that you've submitted to the LWC. They'll take a look at your hearing. They'll take a look at the different laws surrounding your kind of situation, and they'll make a determination whether the ALJ and the LWC was wrong or whether you are wrong regarding your disqualification. A lot of times, the Board of Review, I've seen them do a bunch of different things. One thing they can do, like I said, is they can find in favor of the judge that you were disqualified. One thing that they can do is they can find that the judge was wrong and in fact that you are qualified for unemployment. And then another thing they can do is they can say, look, the judge didn't follow the law in regards to X, Y, and Z. We're going to remand the case back to the judge, which means that your case is going to go back to the ALJ level and that the judge is going to have to follow the law in regards to that hearing. So those are 3 different options that can happen on that level. In regards to the Board of Review finding that you are disqualified from receiving unemployment compensation, you can actually appeal that decision. What you need to do, and I think you have 15 days as well, to file a judicial review in the district court for your parish. And what that does is the judicial review is going to go in front of a judge, and it's going to go in front of a typical courtroom and the judge is going to take a look at the Louisiana Workforce Commission's actions to see if any laws were broken. it's important to note that in a judicial review, this isn't a chance to bring in new evidence. This is solely just to see if the LWC followed the laws. So it is a higher standard of review at this point, and you cannot bring in new evidence at this point. The only thing you can do is just show that there was some kind of law that was broken by the LWC when reviewing your unemployment compensation appeal. So like I said, if you do receive a disqualifying notice that, you are not qualified to receive unemployment compensation, and you believe that you are qualified to receive unemployment compensation, appeal. And just because you receive one notice, that's not the end. There are multiple levels just to make sure that your legal rights are properly followed and that they're preserved. And like I said, always appeal as soon as you get a notice. It's the best thing to do if you think that the notice is wrong. So that way you preserve that right, because most of the time, if you miss the deadline, unless you have good cause, your right to appeal has extinguished. So again, just follow this appeal roadmap. And at the judicial review level, just remember it's a little bit stricter standards of proof, and that you can't bring in new facts unlike the other levels. Okay, so with COVID, things kind of changed a little bit with unemployment. Unfortunately, with federal unemployment that was signed under the CARES Act with the PUA and the PUC, all of this ended in Louisiana on July 31st, 2021. And this has led to several issues that have popped up because of COVID. If you look here at the website that I provided, this is a link directly from the Louisiana Workforce Commission. It's an FAQ page that kind of goes over a little bit about the federal unemployment ending. There's also other issues that we've seen popped up because of federal unemployment. And some of those issues we see multiple times. And so one of those issues is being offered a job, but you refuse the job. At this point, you need to have a very good reason for refusing work. And some of those reasons could be, you caught COVID, or somebody you caught COVID, so now you've quarantined. That's a good reason. Another issue that we've seen is at the time that the PUA was beginning, around March 2020, a lot of people got onto unemployment that with very little review by the Louisiana Workforce Commission. So what we've seen is that the LWC is going back through claims and determining that some people have not been ineligible for benefits since the beginning. So under the CARES Act, in order to qualify for PUA, you need to have a COVID hook. And what we mean by COVID hook is that you have children who were in schools that were sent home to learn virtually because of COVID, that you had COVID, a member of your household had COVID, or that your job closed down because of COVID. What we're seeing is that a lot of people who were receiving PUA benefits never actually had that COVID hook. So LWC is retroactively going back, disqualifying these people, and even though they've paid these people, and that's created the second portion of this, which is overpayments. So if you receive a notice from the LWC saying that you were ineligible to receive PUA benefits, and now you have this huge overpayment, we've seen overpayments up to $15,000 to $16,000. There's several different ways to act in this kind of situation. The first way to act is to appeal the determination that you were never qualified to receive PUA. And so what you need to do in this kind of situation is you need to file a claim and show when you have your ALJ hearing that you had that COVID hook. One way you can do this, and that I've helped clients do, is just show that you have school-age children, and when you applied for unemployment, they were at home doing virtual learning, and therefore you were, as a caretaker, as a parent, you were responsible to be home with them. And so that's one way to do it. And in that situation, if the judge does find that you do have that COVID hook and that you do qualify to receive PUA, then your overpayments are waived. Now, let's say, in the reverse of that situation, you received your notice, you never had school-age children, you never had COVID, and your job did not end because of COVID, you may not be qualified to receive PUA benefits, but you may still be able to get your overpayment waived. The determination regarding PUA benefits and the determination regarding overpayments are seen as two separate issues, which also brings up the fact that if you do want to appeal, you need to file separate claims for each overpayment and the determination as well. But if let's say you had the hearing and it was determined that you did not have a PUA claim, you can still get those overpayments waived. You just need to make sure to file an appeal regarding waiving your overpayments. And the way that you get overpayments waived is that you have to show that it was not your fault that the overpayment occurred. And that the second part of that is that to pay back that overpayment would cause a financial hardship for you and your family. So in regards to the PUA and this kind of situation, a lot of times we're showing, as long as you didn't lie or you didn't commit fraud, it really wasn't your fault because you did file, the proper claim and the LWC approved you. So we see a lot of people meeting that first prong. In regards to the financial hardship, the LWC does send out a form where you can put the money coming in, so you can put your monthly income, and then you can also put your monthly bills, and it's a balancing sheet to see how much extra money you have at the end of the month to determine whether it be a financial hardship. For most of our clients, it is seen as a financial hardship most of the time. You just need to provide any kind of bills. If you pay rent, if you pay a mortgage, provide those notices. If you pay for medications, provide those notices. Any car insurance, car bills, gas, just provide a financial background for the LWC and for the ALJ to see that it would be a financial hardship to pay that overpayment. So like I said, with this federal unemployment, there's a couple of issues with PUA, and the best way to, is to show either that you have that COVID connection and that you shouldn't have to pay the overpayments and that you did rightfully receive the money, or on the other end, just to fill out that overpayment waiver to show that it would be a financial hardship for you and your family to pay back that overpayment. And just to get into a little bit about the ending of federal benefits, I know this has left a lot of questions. Everything on this slide was directly copied and pasted from the handout from the LWC. And what this means is, with the ending of federal benefits, no unemployment benefits will be paid on PUA, PEUC, or MEUC eligible claims for any weeks claimed after July 31st. So July 31st was the end-all be-all deadline. If you become employed by July 31st, so let's say on July 1st you were unemployed and you have yet to submit any kind of claim for unemployment, you can still submit a claim by September 4th, 2021, but you will only be qualified for PUA, PEUC, or MEUC claims for July. So from July 1st to July 31st. Those are the only times that you would be qualified to receive any kind of federal benefits. And then also July 31st is the last date of eligibility unemployment claims will be qualified for the 300 weekly benefit supplement in Louisiana. So what that means is that after July 1st or July 31st, the extra $300 will no longer be available for those on unemployment. The weekly benefit amount will go back to $247, which is the max amount that somebody can receive in Louisiana for an unemployment claim up till 2022. And I believe in January 2022, that amount will go up to $275 per week. Any benefits remaining on either a PEUC or PUA claim after July 31st will not be available. So if you're familiar with HIRE and looking at your claim summary, when you look at your claim summary, they do list the amount of benefits you still have left over. Let's say you have $300 left over in your claim and July 31st comes around and you still have $300 left over in your claim, you are no longer entitled to that $300 that's left over. All the balances go down to zero unless you're receiving state unemployment. Then you still are qualified. And just to reiterate, any pending determinations of eligibility or active appeals on PEUC or PUA claims will continue. Appeal rights are protected under the PUA and the PEUC, and these determinations made after July 31st, 2021 should still qualify you for any of the weeks up to that July 31st, 2021. So I'm going to go into the next topic, which is unpaid wage claims. I see these claims all the time, and so I'm just going to give you some brief information. With unpaid wage claims, your employer has the right, or your employer are required by law to pay employees. So as an employee, you have a right to your paycheck. And what you need to do is you need to first send a demand to your employer, and it just needs to be any kind of formal demand. And then if your employer does not send you your paycheck after a formal demand, then the next thing you need to do is file a claim in your local city court. In these kinds of situations, I always suggest sending a demand through certified mail. So by this, that means sending a demand letter saying, I want, you need to pay me X, Y, and Z. These are the hours I worked. This is a formal demand asking for payment of my unpaid wages. And I say sending it through certified mail because then you have proof that you sent that demand. So when you go down to the next step, which is file a claim in local city court, you can present the judge the certified slip, mail slip that shows that you did make that demand. And on top of that, if the employee purposely did not pay you, then they would be considered bad faith. And what may happen when you have a bad faith employee is that the employer, the employer may be responsible for paying things like your legal fees, any kind of damages that resulted from them not paying your wages, and any kind of other extra money that you may receive from the bad faith action. In these kinds of situations, in regards to the bad faith, having any kind of proof is always going to be best in your favor. And what we can do at SLS is we can actually write the demand letter for you and send it for you. And then if the employee refuses to pay you, then what you can do is you can file a claim in local city court. Unfortunately, SLS is not able to file a claim on behalf of a client in regards to unpaid wages. However, we can help you with the first step, which is demand letter. So if this is the situation for you, just give us a call and we can discuss a little bit more in regards to your next steps in your unpaid wage claim. Okay. And then the last topic was a wrongful termination. Louisiana is an at-will state, which means that you can be fired for any reason as long as it's not stated specifically in federal law. Federal law has a very limited window of protected classes that can't be fired. So, protected classes are race, gender, nationality, disability, religion, or age. So let's say, you believe that you were terminated due to your race, you can file a wrongful termination case. So, what do you do when you believe that you've been terminated due to your race, or you believe that something occurred due to your race in regards to your employment? The first step in Louisiana for filing a wrongful termination case is to file a claim with the Equal Employment Opportunity Commission, which is the EEOC. You have 180 days from the date that the action took place to file a claim. And in Louisiana, the EEOC is located in New Orleans. Their phone number for filing a claim is 1-800-669-4000. Again, I have that on the slide. It's 1-800-669-4000. You can also submit a claim online as well. I've had several people that have submitted claims online. And what happens once you submit a claim with the EEOC? Once you submit a claim with the EEOC, they will get in contact with you to set up an interview to discuss your termination or whatever action took place. And the EEOC will actually go and investigate the situation further, and they will determine whether a discrimination took place. And if they decide that a discrimination took place, what they'll do is they'll send you what's called a right to sue letter. So once you receive that right to sue letter, you have 90 days from the date of the letter to file a claim in court. Unfortunately, SLLS does not handle wrongful terminations. We only give advice in these kinds of situations. But you can file a claim in the EEOC without an attorney, and that 90 days does give you a long time to find an attorney to help you with this kind of situation. And that right to sue letter just means that something fishy is happening and that the EEOC says that your case does have some merit in regards to a wrongful termination, and that the court should be able to hear this case to see if there is a legal action that can be taken. So again, if you have any questions, our phone number is 225-448-0080, and that's the phone number for our Baton Rouge office. I'm gonna exit out of sharing my screen.
Thank you so much. If anyone have any questions, feel free to go ahead and submit the questions. We have a Q&A there we can submit. I also see a chat. If you have any questions for our attorney today, please go ahead and feel free to send those questions at this time.
And the other thing too is if you feel uncomfortable and you do want some advice, do give that number a call, and we can definitely have an attorney assist you and give you very specific advice for your situation as well.
Awesome. Well, we would like to thank you, Ms. Delgado, for everything. It was very informative. Hopefully we have some that might reach out to you with some questions and we can go from there. But I want to again extend my gratitude for everything. And it's been a pleasure. Thank you.
And like I said, if you guys have any other issues, we do handle a whole variety of different topics in civil law. So, just feel free to give us a call. And even if we just advise you, we can put you on the right direction to help get your issues solved as well. So thanks, everybody.